wait just for, okay. I don't know if anybody heard that, but hello and welcome everybody. We're going to wait a couple of seconds until a couple more people pile in. But for those of you that have joined us, thank you so much during this hopping time for everyone for attending live. And for those that are going to hear this via the on-demand replay of the recording, also welcome. We're looking forward to a really great fireside chat. So we will wait just another minute or so, and then we'll get into it because time is short for everybody. And we're very lucky that both the co-moderators and the co-panelists were able to squeeze this in because, as I'm sure it's the same for all of you, they could have still be nose to the grindstone at their day jobs. So at 33 past, we'll go ahead and start in earnest. Okay, again, thank you for making the time. As everyone goes through the aftershocks of the CrowdStrike Microsoft situation, outage for those of you who are directly affected, to listen to the very anticipated, most lively of debates and discussions from a 40 or 50,000 foot level on a topic that's near and dear to CISOs today, helping their US public companies and boards, as well as their delegates in the C-suite that must meet the new SEC cyber rule, as well as private hedge funds, private equity firms, and mutual funds mandated to comply with the recently amended Reg SK and or the NYDFS Second Amendment requirements that include the SOX-like look-back annual CEO and CISO certification for certified entities. Indeed, as these regulators are beginning in earnest to start searching around for possible compliance violations to open up investigations in this new cyber landscape, we will seek to lower concerns, even among those who do not think the pending SolarWinds and Uber investigations for fraud are actually outliers. Time permitting, we will emphasize the importance of GCs also, even if they don't need to be too technology savvy, taking on the critical role of being the liaise between CISOs and senior management, while in parallel, both being trained to speak board from this regulatory compliance perspective, preferably by, and you knew that I would say this, cyber SMB trusted advisors in support of practical and commercially inclined outside counsel, such as both of the esteemed partners that we have as our co-moderators today. Few housekeeping items. To finish my setting expectations before going around the remote room to have both co-moderators and co-panelists quickly introduce themselves, setting the table, and then proceeding on to the talk. If anyone experiences any technical difficulties with the video conference, please contact kdavy@mblawfirm.com. Together with these opening remarks, also in PDF, please feel free to use as a ready reference the e-handout that will be distributed. If time runs short for the Q&A, part of the presentation, attendees, both live and via the recording, are urged to follow up directly with the speaker, or for ease of use, send it to me as the event organizer, and I will play traffic cop. I am at jpwilson@gcracorp.com. Second to last, with the current CrowdStrike Microsoft situation pointing to this issue, registered live attendees or those who will email me, we can arrange a free complimentary cyber resiliency diagnostic review by an acknowledged top-tier multi-billion vendor with no obligation to do anything more, i.e. no one's going to chase you. Finally, please note that this event might be the first of two, with the second possibly happening around mid-September, to be directed at boards and their C-suite delegates to discuss related issues that are on the other side of the coin to support today's takeaways. None of you thought I could do that in 2.5 minutes, and I did. This is the advantage of being a fast-talking New Yorker. So I will turn it over to David Nevada from Cooley to set the table from a regulatory perspective for CISOs and their GCs. And then we'll go over to Steve Tepler at Mandelbaum Barrett. And then we'll let those two guys pepper Patrick Benoit and Scott Foote, both esteemed, highly regarded CISOs and consultants, cyber risk management and board advisory consultants, to throw the medicine ball, around. David?
Thank you, JP, and thanks for joining us today. Really appreciate it. In preparing for this conversation, we've already had a lot of fun, and we're going to have a lot of interesting angles on the various issues we're about to speak of. Big picture wise, JP already alluded to a lot of what's sort of happening out there, right? We're at I would say, an inflection point where the SEC rule has come out, and companies have begun reporting data breaches via 8K and otherwise. But also, concurrently, the SEC has been pretty aggressive with respect to its enforcement activities. Just a week and a half ago, they settled with R.R. Donnelley with respect to certain allegations related to R.R. Donnelley's alleged failure to respond to security alerts. That was a $2.1 million settlement ultimately. And then on the heels of that, we had a court decide to throw out many of the claims made by the SEC against SolarWinds with respect to their data breach. And then, by the way, that particular action named the CISO, or security professional, leading SolarWinds as an individual defendant, which is really the crux of why we're here today. What we're seeing is CISOs potentially on the front line, of course, always around helping to secure their organizations, but now potentially on the front line of being involved in legal actions associated with their decisions, or I would say maybe more accurately, the decisions of the organization ultimately with respect to security. Some of those decisions may not be fully reflective of what these CISOs want to happen, and we're going to get into that. On the flip side of that, the issue around security and cybersecurity and dealing with the risk of it has now been elevated to the board level very firmly. We're seeing a lot of boards out there asking questions perhaps they didn't ask before. Also feeling that they're also on the hook to some degree. They have some skin in the game. So that level of visibility obviously gets the attention of top management, which potentially gives the CISOs and security team a bit of leverage, perhaps, to get more done than perhaps in the past. So we're trying to figure out here with this conversation, talking to Scott, Steve, and Patrick, whether these activities by the SEC and other regulators and these new rules, are they helpful for CISOs and similar professionals, or do they hurt those professionals and make it more difficult to achieve their goals? So that's the debate we're going to take on today with this great crowd. Steve, anything to add to that? Oh, you're on mute, Steve.
I think you've covered it quite well, David. It's a, I keep thinking that it's trite to say this, but we're at war, and especially in the last few days, I'm seeing an uptick of events, of cyber events that cannot be coincidental. We're not sure where exactly these are coming from, but the heightened focus on public entities, or those entities that have to file, is something which, in my view, is in a way a long time coming. But in another view, as David has mentioned, this places the CISO in a role which has always been dynamic, but now is dynamic in stage 4 rapids. So with that, I think we can. And I think we can agree that it's you all have paddles, but they ain't big enough. And so part of what David and I both do is we try to help you navigate that, But, the tension with that you have, representing the company and then having to address the internals that may provide either facilitation or blocking are things that we're going to be talking about. And in a way, and again, as David said, the new rules are actually may offer a window and an opportunity to better perform as a CISO, because you'll have the kind of backing that you'll need. And we'll talk about that as we go along. What do you guys think about that, Scott?
But in a word, Steve, I would say the SEC has raised the bar in terms of obligations. Right? When I'm speaking in the boardroom or with the C-suite, and I'm a virtual CISO for we're a small consultancy. I'm a virtual CISO for maybe half a dozen companies right now, but I'm also a data protection officer. And when I'm in the boardroom or I'm talking to the C-suite, I'm not talking about technologies. I'm not even talking about specific threat actors. I'm talking about the obligations that the company has, public or private. What are their obligations to their stakeholders? That could be certainly shareholders, but it's also customers, of course. It's employees, it's partners. What are those obligations? The SEC allows me to put that word in bold and raise it up to 72-point font. Every briefing starts with that. I'm not here to tell you what I want to do. I'm here to tell you what we have to do to comply with those obligations. So I do see the SEC raising the bar as a positive thing, as long as the accountability is properly placed. Early on, the SEC, we've talked about it ourselves. We've been on some previous calls. Some of us have been together. We talked about it drawing a target on the back of the CISO. And my ubiquitous response there has been, hang on, the CISO doesn't decide. The CISO raises awareness with due diligence and makes recommendations on due care. But the CISO doesn't unilaterally decide what controls are going to be implemented. That's up to the executive team. Now we go implement. If you want to hold CISOs accountable for our implementation of what others have decided, that's a good and useful thing, right? You don't want to see malpractice where somebody said they're going to roll out privileged access management and did a terrible job. That's on the CISO. But the decision whether or not to go with fortifying privileged access management should be one that's made in the C-suite with the support of the board. So I think it's raising the bar, it's helping. And I think most CISOs would say the same thing, but we're all keeping our head down a little bit saying, just don't misapply this new lever. And certainly the adversaries are seeing this as saying, I've got even more leverage now as a threat actor because companies have even more to lose. And I'm sure Patrick disagrees with all of this. So let's hear what Patrick says.
No, I don't really disagree with that. I think it does raise the bar. I think that there's a couple of interesting points in that. One is that the SEC has created a scenario where we're kind of running down a slippery slope. And that slippery slope, when taken to the greatest extreme, would be very, very beneficial to those folks that don't want to be a CISO as an employee relationship with the company. Because now if you have a contract relationship, you're in a different scenario. You're not agent for the company the same way. You don't have the same legal liabilities. Not being a lawyer, but having stayed at Holiday Inn Express, I think that relieves you in some way. You're providing consultancy and advice. And that's a different position than being the CISO in a company. And I think these kinds of rulings that don't also require the accountability be placed in the right place that you've mentioned, Scott, drives the industry and those in the career towards that idea of let's work from the outside in instead of being part of the inside. I think there's also this drive towards failing to realize that companies view the money spent on cybersecurity as a finite resource. Money spent is a finite resource anyway. But if you look at that 100% pie of what's spent on security, more and more and more of it is being spent each year on compliance and risk management. And the more we spend on compliance and risk management, unfortunately, generally means less is spent on actually protecting and defending, the operations. And so at some point, you get this imbalance of you're telling everybody that you're complying, but you don't have the money to actually do the defense and protection that you want to do.
Let's step back a little bit here and talk about the role, right, of the security professional. We've had a conviction of one CISO, another being named in the SEC action. How are CISOs, feeling right now relative to their role? Do they feel they have that target on their back and such that they're being more hesitant and more careful, or are they taking that pent up demand I mentioned and really going out there and laying it on the line in front of their senior officers and boards as to what's really going on within the organization? Where are we with respect to that?
Pat, you want to start this one, or you want me to
Yeah,
open the
yeah.
volley
So
here?
I think we're in some ways mired in an evolution of the CISO role itself. Let's look back and just say it's very, very similar to the evolution of the CIO role. Years ago, you had director of IT, et cetera, et cetera. They reported to finance. They reported to everybody but the CEO. They finally proved their business chops and they became reports to the CEO in most cases now. We're seeing the same thing in the CISO world. Reporting to the CIO, I think the last stat I saw still says 64% report to a technology officer of some sort. And so we haven't proved our business savvy yet. And as a result of that, I think we have that we're being given responsibility or accountability without necessarily having all the responsibility we need to make it appropriate. And I don't think people are really running, David. I think a good CISO that's a good business leader too realizes that the best you can ever do is the right thing. And now the right thing just includes making sure that you are well documented on what it is you're doing and who's making those decisions.
Well, what's interesting as you bring this up, and I keep thinking of the title, chief. Chief. Usually chief means C-suite.
What's little c,
Yeah, little c, except it doesn't come out that way on any business cards I've seen. And I think that when the SEC, does trawls through an org chart, no matter where that CISO falls, whether it's under the CIO or this, or the CTO, he's going to be or she's going to be pulled in. And I think, my conversations with the three of you and with JP has been, you're doing all this legwork, you're protecting the company, you're neither getting the recognition, the privilege escalation and the remuneration for the risk that you're taking, right? I mean, for all of the risk assessment that you do for the company, the risk assessment internally for your working as a chief information security officer, I think is not well recognized by CISOs, and the degree to which, especially with it's not only the SEC new rules, you've got obviously DFS Part 500, you've got General Business Law 899 BB in New York. All of these point to who most easily will be thrown under the bus. And the risk reward ratio, I think, is a little bit out of whack from this.
I would agree with that point, Stephen. Sorry, go ahead, Patrick.
I was just going to real quickly say, I think it begs the question of, does a CISO really have any less liability than, for example, a CFO?
Right. If you have a regulator come after you, the answer is no. It's the regulator's choice. I mean, David,
CFO might have D&O insurance, and the CISO might not, though. So that's something to be aware of in the CISO community.
Right.
So that's another piece of what Steve had said, focusing on obviously the modifier chief up front, but look at the end of that, right? Officer. I don't know of any CISOs, even of very large public corporations, that are truly listed as officers of the business. Some of them, of course, are put on the D&O policy, but I don't know any of them that are listed in the 10K as an official officer of the company. So the role it's arrived at the level of accountability without the appropriate authority, I think, certainly the compensation package to cover the amount of risk. That's where, my comment before was, okay, good, the SEC's raising the bar. That helps me make the argument, we have to do this, it's not optional. But if they raise the bar of my personal risk, what's going to happen? I'm either going to go in and negotiate for a bigger package, or one of the themes coming out of RSA this past spring was that many CISOs, although they're not running from the role, they're doing what I have done, which is step back and say, I'm going to do this as Patrick has described. I'm going to do this independently. I will do this in an advisory capacity. So there was generally, I don't know that anybody was gathering any real data on it. It wasn't Gartner, Forrester, or anybody like that. But there was this general impression that a lot of full-time CISOs were saying, I'm still committed. I'm still going to be in the game. I'm still going to raise the awareness because that's the cloth we're all cut from. We don't, recede from an adversarial circumstance. But I'm going to take my own personal liabilities and push them back a little bit and just make this, and like an external law firm, I'm going to behave like an external trusted advisor rather than be full-time on the books.
But as an agent, and this is where David and I would take a look at this, is that a flimsy insulator?
It's definitely not perfect. I'll
Also,
tell you that personally.
Is it
It's
a
not
step?
perfect.
Is it a step back too? I mean, let me put something out there this way. I think now with the SEC rules, you've got some allies. Certainly, one you didn't have before. Potentially, the board, right? They were always always interested in security, but now they're really interested. So, and this goes to what Patrick was saying, the lines of reporting, right? So I think it's easier to get a direct line now for you guys to the board, right? And to actually leverage that relationship. I also think you've got two lawyers on here, right? I think there's opportunities relative to the GC as well. And so is it a situation, Scott, where you sort of step back and take that advisory role, or do you go the other direction and say, hey, now I need to be recognized at that level of accountability, officer level, et cetera, which means I need to have more independence, more of a direct line of reporting into top management, boards, et cetera. Can you flip the script a little bit there?
Oh yeah, no, I think the going in argument is you start with saying, no, first of all, the reporting structure needs to improve so there aren't any conflicts of interest. Secondarily, the comp plan needs to be associated appropriately with a level of risk. And third, I need to be able to have that freedom through general counsel under privilege to be able to communicate very frankly about where the risks are in the business. But if you don't get that, and a lot of CISOs have played this card over the last 24 months. You don't get that. That's the time to step back and say, okay, maybe I do this as an independent individual. To Steve's point, that isn't a whole lot of protection, but that is a fallback. And I don't believe it's going to last long, Steve. Maybe that'll last a couple of years until the CISO role takes the similar trajectory the way the CIO role has. And is elevated a bit more.
Yeah, I'm sorry. I was just going to say, I think, when with Stephen's comment with regard to it's a limited shield, that's right. And I think we're skirting what really is happening when you take that step back to be the VCISO or the advisory role is when you become a consultant, an advisory, you take a decidedly very different approach at everything you write, everything you say, everything that you do for the company. Why can't we be a CISO in the employee role and take that same consultative approach to our language, to our documentation, to everything that we do? And now, Stephen, we haven't taken that step away, so to speak. We still are part of the company. We make sure we're under D&O, but we just treat it more consultative so that we're giving advice and it's very clear that that's what we're doing and we're taking those.
In fact, one of the attendees, I'm sorry to interrupt, but one of the attendees, E.J. Hilbert, who actually responded to a LinkedIn article that was put up on June 30th, asked the following: does the CISO implement? Most CISOs own policy and incident response. They don't own IT procedures. They tell the IT team that they must do X, Y, and Z, but the CISO does not own the implementation. What do you think about that, Scott? What? It's a mix?
Yeah, it's a mix because, and I'm sure Scott's seen this too, depending on the company, they may not implement everything, but certainly, you know, like my teams have always had responsibility for like implementing identity and access management, or implementing, you know, the various detective and protective controls that are in place, vulnerability management, and all those kinds of things. So I think it's a good.
Patrick, you just,
So-
right at the end, you
Oh, you cut
muted
out
there.
Patrick at the very
Good
end.
end it.
Just a
you know,
couple of, I'm
go
sorry,
ahead.
Steve, go ahead.
No, go ahead, Scott.
So a couple of quick rounds there to agree with Patrick. So we do implement some things. It depends upon the size of the business and the staff and how IT is arranged. But, and by the way, EJ, thank you for being here. Really appreciate it, buddy. Thank you for your service as well. But your point is well made. We don't always implement, but almost always, and I think Patrick will see this as well, we operate. I may not implement PAM, privileged access management, right? But I'm sure going to operate it. So that's where the discipline needs to be. We definitely identify controls. Ideally, they're going to be deployed, whoever it is that's actually doing the implementation, but the operation comes down to my team. And in many cases, I've got security ops, I've got security architects, I've got identity and access management, where you're constantly onboarding and offboarding, whether they're staff, full-time, part-time, vendors, customers, whatever. And I've got GRC as well. So we are the operators of that infrastructure. But Steve, I cut you off. Thank you for
Oh, no,
letting me empty those rounds.
that's fine. Those are great points. One thing as a follow-on is, you know, how do you empower a CISO to get to where he or she needs to be in terms of you know, in terms of being able to push the board into making the decision to do the resourcing. The SEC rules obviously are very helpful, but what I've found helpful is, and I'm sure David has as well, is supporting the CISO's findings, the risk assessments, to say, all right, the CISO says we have this gap, we are not compliant with blank. It's my job, it's David's job, and I don't mean to speak for you, David, but if I contradict you, let me know. It's my job to say to the board, what he's saying is that you can be held liable for a variety of regulatory or legal requirements that will result in this type of financial consequence, or litigation consequence, or regulatory consequence. And if you don't do it, guess what? It's now documented. And, you know, and we protect, in a way, you protect the CISO, but you also provide notice to the board that it makes it incumbent upon them to make the decision whether or not to act upon that.
I will take a slight issue with certain aspects of it, because the documentation part of it has been mentioned by Steve as well as Patrick. And I think, again, this is where I see overreaction sometimes from the security team, where the documentation is sometimes speculative, maybe overly alarmist. You have to, there's a balance, right? If you put things into the record, because at the end of the day, all this documentation, most of it, a lot of it is going to be discoverable, right?
Correct.
Attorney-client privilege will take you only so far. I usually say to clients, pretend like, you know, act as if it's not protected, even if we're trying to protect under privilege, and write and advise on that basis, right? So I think we have to be very careful. And in fact, part of what we're doing now is working and doing communication training with security professionals internally to help them understand, you know, especially in the informal channels where we all kind of, you know, maybe go off the rails sometimes when there's an emergency, to be careful that something you put into writing can't be taken out of context, can't be, I would say SolarWinds is a perfect example of that. The SEC's allegations, sifting through Slack messages, emails, reports, finding inconsistencies, right? That type of thing is coming back to haunt
And
departments.
and it's not a boy who, you know, we're in violent agreement. The issue is not to have a boy who cried wolf, the sky is falling every time you see something happening. We're talking about a problem, right? And that's where the role of the lawyer comes in, to assess, to say, is it enough to make noise about, to reflect? And so we are in agreement on that.
There's
Also,
two.
we lose credibility as lawyers if we keep coming back with every every little nick on on a shave.
There's two behaviors that I've noticed over the years that continue to raise their heads, not as badly as they used to. One is that we have technology leaders who still think they have a good grasp of security if they're not security specialists. And so there's a tendency to only cursorily listen to the CISOs when the CISOs are telling them something. Now, many CISOs have not done themselves any good by not being clear, or being vague or being too slippery in terms of what you're saying. And so we have culpability in that too. But CIOs have to stop approaching it from the point of view that they know technology, therefore they know security. The same way that some executives have done that by, reading the magazine in the back of the American Airlines seat that they're flying on, and Forbes tells them something, and they believe that it's real. So they have to start listening like a good leader does, and ask poignant questions that are specific and make sense, but stop assuming or assessing themselves as having more security knowledge than they may really have.
Never happened to me, Patrick. That's never happened to me.
Could I step in just for 2 seconds? Because I think I'm the only former SEC enforcement guy on the screen. David, Steve, am I wrong in saying the following? That the major thrust of the new SEC cyber rule and the quote unquote Me Too of the NYDFS Second Amendment, which has, as I noted at the beginning, that annual look back, SOX-like CEO, CISO certification, which if the CISO refuses to sign is a huge red flag to the commission, as well as to the NYDFS. Would you agree that the main thrust of the new regulatory landscape is not on the 8K filing within 4 business days of, although it's important, not diminishing it, but of material data breaches, but is the new cyber corporate governance of boards with respect to oversight as relayed or transmitted through the annual report, the 10K. And although they don't have to file 10Ks, obviously, private funds through the Reg SK. Meaning, the requirement of the new commission rule says 3 things. I better see an item, is it 1C or 6C? I think it's 1C. It says, I better see accurate representations as to cyber risk management, cyber risk strategy, and the oversight that I just mentioned. And if I catch you doing aspirational, pretending that it's real, you're going to have a problem. Now, I don't see how that, I think that fits hand in glove with what everybody has said. You stay in your advisory role, you don't sign anything. I don't think you can sign the 8K, as David said in our prep, right? You stay in the advisory role, you keep a CYA file, of course, but really the hollow point bullet has been, you as a CISO have been removed from the line of fire, and it's now heading towards boards and their delegates in the C-suite. Am I fair in saying any or all of that?
I think it might, I mean, that's a lot to say, right? I think that CISOs are still in the line of fire. I think that the general idea is to try to have more accountability at the board level and the management level, right? For the SEC, they've been going after companies for failure to elevate certain types of issues to management so they can make materiality decisions, right? But in every case, what they've done is basically looked at the incident response plan, which is the area that CISOs oversee, and said that this was faulty, this was a problem, this is a security issue. In fact, I would argue the SEC is maybe even going beyond their mandate, and I think the SolarWinds decision sort of supports that. So at the end of the day, while there is, I think, more spotlight on those higher management roles and board, I still think things fall onto the CISO ultimately. Now, again, I don't think that means every CISO is going to be named as an individual defendant, but the responsibility, as said by Scott and Patrick, is still going to be, whether it be their job being lost or something else, is still going to fall on the CISO for the failures of potentially arguably management and or the board to do the right thing relative to security. I still think
So,
that's the case.
I
David,
respectfully
you
demur, but
mentioned-
go ahead.
David, you mentioned the IR plan, right? And the plan, who executes that plan, right? Again, it's an operational thing. If the CISO is supposed to execute on that, what type of coordination is done with the CIO? This is all of a sudden become an escalation of prominence in terms of risk and just general operation of the entity. And I think that gets overlooked.
Well, and I think to
Go ahead,
say,
Scott.
David, I think to your point is that if the plan was faulty to begin with, it doesn't matter how well you implement it. And I think that's what I got from what David was saying.
Well, but you get hit on both ends, don't you? Because
That's right.
Stephen's point, this is what happened in R.R. Donnelley, right? They had all these alerts and they didn't get elevated properly, allegedly, to the CISO in that case. And so they had actually a pretty nice, robust way to detect and respond with the managed service provider. But again, the SEC alleges that they didn't get things done quickly enough and they didn't connect the dots. So you're getting it on both ends.
And
So
David,
let's pull the thread on that, because there's multiple pieces in there, right? You just talked about the monitoring detection piece. That's actually not part of the incident response plan. That's part of the, how do I figure out when I've even got something, right? Is that a tiger in the grass or was it a chipmunk that just ran through? And every program I've ever seen needs work there, because the adversary is much better and much better resource. We're constantly evolving. That is at the root of what we just saw last weekend with CrowdStrike responding to something that was otherwise invisible and needed attention quickly. So that's important. But I don't think it's fair to assess anybody on whether or not you can catch everything. The second piece is having the IRP written. I've seen IRPs that were terrible. They were written on napkins. They're just horrible. It's got to be good. But Patrick also made the point, it isn't enough to just have the plan and wave it around and say, look, it's all standards oriented, isn't this wonderful? If you can't execute it and do a decent job in all pieces of it, including comms in coordination with not just IT, the CIO, but the C-suite and the board, all directed appropriately through single points of communication. So there's opportunity to trip all the way along. Protection, the planning, as well as the response. But Steve, you had a thought. I did want to take us back to what I think it was JP that was pulling on the thread of the 8K is about responding and making people aware that you've had some type of a material event. The concern I had when they first put these out, and I commented on it over a year ago, almost 2 years ago, was the business about, wait a minute, you want me to report on the risk profile in the 10K filing of a public company? Why don't I just send out a blast to all the threat actors on the planet saying, my PAM sucks. That's the place to target privileged access management. Once you're in, you got lateral movement and escalation of privileges.
This reminds me of all the people who have said, we've been affected by the CrowdStrike issue. Thank you very much. We're sending that social engineering stuff right knocking
please
on
stop
your door.
informing the adversary that was a fundamental
But
tendency
you raise a great point. What is the balance? What is the language? I mean, obviously, writing for an 8K is an art, right? It's not human English. It is designed for a very specific purpose. The question is, how do you shoehorn what you need to, the minimum of what you need to disclose to satisfy the requirements while still protecting the infrastructure, while still protecting the enterprise? And that has not been, I don't think we're very far down that road in understanding that yet.
Well, let
And who
me
do you
give
think
one
the first
absolute.
people are that read the 8Ks? Who do you think the very first people are reading the 8Ks? You think it's the investors, the institutionals,
securities lawyers?
I'll bet you threat actors.
Yeah.
The
Oh,
threat
yeah, yeah.
actors sit and wait for that intelligence to be released.
Yeah, guys, I don't think that those AKs cause all that much risk. I mean, they've been drafted in a way, to Steve's point, to be just like right up to the line of compliance, basically. Same thing with 10K.
Yeah.
I've not seen anything.
What about the 10K, David?
The 10K,
Same thing.
I mean,
Same thing.
I've
Well,
helped.
but David, there's one absolute though. There's one absolute I'll throw out there. Anybody who writes a 10K or an 8K that uses adjectives should be shot. Just remove adjectives from your vocabulary.
Get
There's
rid of
no such thing as a robust cybersecurity
best
program.
practices is the worst two-letter word you could have in information security, as well as on the legal side. Because if you say that and you have no tether to what that means, how do you know what's the best practice? Why are you saying you're doing it when maybe
Right.
that's a whole nother, we can go on forever on that one.
Steve, as cybersecurity counsel to guard and protect CISOs, are you saying that there is not 100% insulation that can be put in play so that the CISO does their internal consulting role, works with the GC to liaise to senior management, to wave your hands, or to wave their hands, because they've been, senior management has been trying to put this off for some period of time? Is there no way of insulating a CISO?
I think it's a challenge. I think it's a big challenge. Where there's a will, there's a way. And regulators, especially.
Of course, a lawyer would say it depends.
No, I'm not saying it depends. I'm saying it's very likely that you won't be able to duck and cover. In this environment, there are, regulators in particular have huge amount of inherent discretion. And even if they're wrong, right, and they push you through this entire regulatory investigation, et cetera, process, you've still been tagged. And the costs are still there, and the resources are still there. So
shouldn't there be some reliance on, I mean, there is regulatory compliance. And that's the thing where, you didn't comply for whatever reason. Okay, that's a non-compliance issue. I get that. But shouldn't, just like, again, not being a lawyer, but don't most things require to be really liable for it some level of negligence of some sort, that you did something wrong? I mean, you purposely did something wrong.
So it's not negligence, Pat. That would be intentional negligence.
Gross negligence, whatever.
Or gross negligence.
Yeah.
Just mere negligence is not going to get you in trouble.
Okay. But I don't even hear any discussion surrounding CISO work that even talks about, was there any form of negligence involved? If there's no form of negligence involved, should somebody really be held liable beyond a normal, hey, an accident occurred and I was the one that pushed the button? Or
it's a good question.
I mean, negligence is a low standard, actually, right? I think to JP's point, it needs to be more like intentional. Even gross negligence, that's a very fuzzy line, right?
Right.
My view is, if you have reasonable policies, you follow them, and yet you make the wrong call for whatever reason on a reporting or not reporting, you should be let off the hook. It shouldn't be strict liability. And so the question becomes, what's a reasonable policy, and how well have you implemented it? And can you establish that after the fact with, the Monday morning quarterbacking happening by the SEC? Because usually you're going to be defending something where everything blew up, right? And you're going to be arguing, despite the blow up, we had reasonable procedures and followed them, and therefore we shouldn't be liable. And Steve could speak to it. It's a very tough position to be in to defend that.
I'm sorry to raise my hand, but as the event organizer, I just want to say it's 3:15 now, local EST. We're supposed to, I'm sorry we blew through the Q&A. If anybody wants to hold on, it's a great conversation, obviously. I think we'll continue for another 15 minutes, but if you have to leave, you can pick up the rest on the recording. Steve, go ahead.
So I'm in total agreement with David on this. You have to look at reasonableness as an after the fact determination that is an objective determination. It's some third entity out there that in your position at the time would have done X. And if you did Y, then you can be seen as being negligent. Okay. What we look at, and I think David looks at as well, is, you know, the before, which is how do you make what you do defensible? It's never going to be perfect. It's the defensibility that you have to aim at. Once you have defensibility, you'll more than likely have that reasonable standard met after the fact.
And Steve, when I set up a program, I just very quickly, I just want to slip in a couple of legal terms that, and again, I'm not a lawyer, but boy, have I carried these ever since I heard them. Because the judge said to me, I was the expert witness trying to determine reasonableness of someone's program after the fact.
And there'll be experts on both sides of the fence that'll say, oh, yes, and
absolutely.
It'll be a party.
The judge charges you, and I said, now, how do I assess that? And he says, first, due diligence. Did the defendant apply a level of due diligence to the reasonable person standard? Yes, he went and did his homework to figure out what the hell that was. The second was due care. Did they make reasonable decisions in terms of the controls that they did apply or the mitigation treatments? Due diligence, due care to the reasonable person standard. When I am sitting in the chair trying to assess reasonableness, the first thing I looked at, Steve, is how well were you prepared? Did you document? Did you follow the procedures that you had written? Did you keep your evidence in play? Did you not speculate in your communication, but stick to the facts? That's what I want to see if I'm the expert witness trying to assess this nameless defendant in terms of the reasonableness of their response. If you're not documenting anything, I'm sorry, it's lights out. I mean, I have nothing to go on, right? As an expert witness, I have nothing to go on to establish that reasonable assessment.
Could we take a lesson from the aviation industry? Potentially, they have a program, aviation safety reporting system, that basically says that if something happens, you violated a federal aviation regulation, but there was no malice, there was no, you weren't, and there was no big accident or anything like that. You violated, you crossed the line on the runway you weren't supposed to, and you self-report. You have immunity for that self-reporting, and they use it to improve the system. Could we get somewhere like that?
That makes too much sense for the SEC. I'm sorry.
I believe Ohio, one of their state laws has an immunity standard built into it. And it's a good idea, but that takes away the power of the regulators, right? So question is whether they would go for it ultimately, and how broad it is, and really what it means. Immunity, though, would probably come down to the same questions and issues that Scott just mentioned, right? Like, if you want immunity, you're gonna have to show that your program was good and that you put thought into it. And what I describe it is, this is where Steve and I operate. We're usually between the general counsel and security team. I say to the security folks, what this is about from a legal perspective, compliance perspective, is the story of your information security program. That's what you need to be able to tell on the stand. And you can't tell that unless you deliberately document the decisions and the trade-offs that you've made in developing whatever it be, the incident response plan, the information security program, whatever choices are being made, pro and con. You have to, at some point, remember, first of all, why you made the choice. And then secondly, be able to explain the story of the plan and why it ended up where it was. And at that point in time, it was completely reasonable and fine, despite whatever bad thing happened. So that's goes back to the communications, ultimately.
And to pick up on that thread for 2 seconds, one of the things that we haven't touched on, which I think is a gravamen, is that every policy and procedure, tell me if I'm wrong, David and Steve, but every P&P must be, particularly with respect to cybersecurity, is driven by the tone at the top, is driven by the then existing appetite and tolerance for total enterprise risk, of which cyber and regulatory is a piece. Is that fair to say?
I don't disagree with it.
What?
I don't disagree with it.
It helps, but it's a very vague concept, I have to say.
That's faint praise, but I appreciate that. I'll take what I can get. Because I want to keep the focus. The purpose of this thing that I organized with all of these fine, really great speakers. In fact, one attendee said, a wonderful, lively conversation, is that the focus really has been now placed squarely on the shoulders of senior management. And they may try to dangle a CISO to give, to make an off, a sacrifice to the gods, as has been done many, many times in the past. I don't think that's going to work as well, particularly if the CISO stays in their lane, has a good CYA file, and if I was giving testimony to one of David and Steve's clients, I would say, okay, at the time of the traffic accident on the highway with a busload of 6-year-olds, what was your appetite and tolerance for cyber risk? I'm asking this of the board chair or the CEO.
And
Scott,
I don't think there's
you're about
one
to kill
answer.
me.
I don't think there's one answer to that, right? I don't think the board has a single risk tolerance or threshold. I go through a risk matrix, risk registers, and for each risk, we talk about their tolerance for risk of that scenario. And they may have a very high tolerance for a particular risk because the cascading effects are simply not going to be that damaging.
Mm-hmm.
Where they may have a low tolerance for risk where, say, lives are at stake. Right? There isn't a single risk threshold. When we sit down with them, we do the traditional, here are the top, X risks that you're focused on. Qualitatively, quantitatively, here's what you're carrying for residual risk. Are you comfortable? My favorite question in the boardroom is, are anybody else uncomfortable with this register?
Yeah.
And you see
Well,
everybody start to shift their weight around. Well, let's talk about which of the risks you're not currently comfortable with and why, and what could be done to drive down the risk threshold, drive down the risk against your risk threshold for that risk. So it's very circumstantial. And I hear people try to define what is risk threshold, what's risk appetite, as though there is only one for a company. And I don't see it personally.
One of the
well,
attendees
and
asked,
Scott, you
I'm sorry, Pat, go
oh,
ahead,
wait,
please.
hey, JP, I was just going to say, Scott, you're spot on, but I remember reading a book years ago about quality, and so I look at risk tolerance much like looking at quality. And the moral of this short fable story was, you'll know it when you see it, and that's the way people's risk tolerance is decided. They may say that they have a tolerance at certain level for risk in the board meeting, but wait till it happens. That's when you'll know what their real tolerance for risk is.
Well, I mean,
What I
the
try
other,
to do, guys, is I try to get them to put it in writing. We have something we call risk level agreements, just like service level agreements, risk level agreements. And Patrick, I make everybody initial the decision. Are we all comfortable with that scenario? We're going to carry $11 million annualized risk on that scenario. Are we comfortable with it? If you're not comfortable with it, we need to take it back to the drawing board. Otherwise, you're putting your name on this decision.
Oh,
And it
absolutely.
becomes a corporate
I hold them
record.
accountable. Yeah, that's great to hold them accountable. But I'm telling you, their risk appetite will change in the moment too. And they may have
Oh,
to
it
live
does.
up to what they decided, but they're going to change their appetite when it actually happens.
Is
Oh,
this
yeah.
is this an outgrowth of all plans go to hell when the battle begins?
That's it.
And how did you know that Patrick is a veteran?
The language. Language is clear and
Uh-oh.
straightforward. One thing that we haven't raised is, what does CISO do to protect him or herself? Do you need a lawyer going in? To flesh out what needs and what risks are uniquely attendant to what you do. And maybe that's something that should be addressed. And then, once the organization is sued, because even despite notwithstanding reasonable security measures, plans, policies, and procedures, you get called on the stand and have to testify basically in an adverse manner to the company's interests by saying, yes, this was a problem. Yes, this was a problem. This is kind of an inevitability for CISOs and should be taken into account when you think about entering into a contract with your employer. Not necessarily to say that CISO needs the employer to do a risk assessment before it takes the job. But certainly, in a perfect world, that's something I would want to have, because I'd want to know the plate that my client was about to partake in at the feast.
But Stephen, I think except in the biggest companies, most CISOs don't get any kind of a special quote contract. They're getting a standard employment letter. We're talking about at-will work in most cases. So the only thing I do consistently is I go and I ask the HR or the insurance attorneys to send me the language and to verify for me so that I have a record of that I'm covered in D&O. That's the first step. I have in the past also asked for letters of indemnity, and I've been laughed out of the room, but I asked, right?
Can't get it if you don't ask for it.
I don't think they're going to be laughing much anymore.
But Steve, you asked a very provocative question about, do you need a lawyer personally? And I always recommend for rising CISOs, there was a good question from Claudia here, why would anybody want to do this job? Well, for a rising CISO, this is what I read them in on first. This isn't just an executive position where somebody hands you a whole lot of authority and a budget. You're taking on personal liability, as most executives do. So I always recommend two things. The first visit on your first day is to the general counsel's office. You're going to be attached at the hip with general counsel. The second is retain an independent attorney.
Hello, Steve.
Oh, I'm here. I
just gave you the, Scott opened the door for you. You were supposed to walk right through.
Oh, no.
As well as David.
How can I disagree with that? This is an emerging area. I think that as both the prominence, the responsibility, the potential liability, and the remuneration grows, that I'm almost using the analogy of athletes. And there are going to be star CISOs, and there are going to be rising CISOs, and I think you have to look at the type of agreements that protect these people as something that's going to be of increased. It will have increased attention and scrutiny.
We're not talking about a lawyer in the midst of the actual creation of a security program representing the CISO, right? We're talking about pre-employment, right?
Pre-employment. Oh, no.
You can't have a lawyer
Yeah.
individually representing a CISO, helping them navigate, the development of an information security.
Oh, no. And
but it's interesting from an individual point of view. We're getting into this whole idea of legal representation, but that also then drives into the idea of personal type liability insurance as a CISO. But let's not overlook the fact too that the insurance companies, much like they did for the aviation industry, they are coming to bear more and more upon what security programs must look like. And we're going to see that only get worse and worse and worse. They're going to drive the boat just like they did with aviation.
Hello? Did we lose Patrick? Did we lose you?
He just muted it right at the end of the sentence, but yeah.
Just went off. Yeah.
And JP and team, I'm going to have to drop. I've got a hard stop here with a staff meeting, and I'm running it, so I better be there.
Well, it was a lively conversation. So what's the verdict? The rules help or hurt, or a little bit of both?
Yes.
Both.
Both.
Let's do it.
They will help, but there's great potential for them to be used inappropriately.
I'm practicing my legal responses. It depends.
There we go.
Good. You've just gotten admitted into law school.
So I will say, I think it's clear there's an opportunity for CISOs to leverage some of this. How you do it,
absolutely.
All the permutations and difficulties around it. That's maybe another presentation.
Definitely a bit of a minefield to navigate. So it was good talking to everyone.
Which, we have that thing coming up maybe in September for the boards and their general counsels and their C-suite. So be on the lookout for that. And I think with that, we ended up at the halfway at the bottom hour. Thank you. Really lively as I expected. Pat, Scott, and of course, our esteemed outside counsel, Steve and David. Please come back to me, as I indicated. If you have any follow-up or questions or issues, jpwilson@gcracorp.com. And that's it.
Thanks everyone.
All.
Cheers.
Stay safe, everybody.
Thank you.
Bye.